everybody. Welcome to a Bentsi-Enchill Letsa Ankomah podcast. I am Daad Akwesi, a partner in the Dispute Department and Head of Civil Litigation. I am joined by
Ms. Gloria, Cofie, also a partner in the Disputes Department and Head of Regulatory Investigations and White Collar Defense.
Welcome, Gloria.
Thank you, Daad.
Today we are discussing the Land Act 2020, Act 1036, specifically Section 47, which deals with the restriction on transfer of land by a spouse in a marriage. Section 47 is one of the new provisions introduced by the Act, and it seems to want to enhance the rights of spouses in dealing with land acquired during the marriage for valuable consideration. Now, please take note of this phrase. We'll be using it a lot. Land acquired for valuable consideration during the course of the marriage. And for the sake of our listeners, I am going to read Section 47. Except as provided in subsections 3 and 4 of Section 38, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right or interest in land acquired for valuable consideration during marriage, A. Sell, exchange, transfer, mortgage or lease the land, right or interest in the land. B. Enter into a contract for the sale, exchange, transfer, mortgage or lease of the land, right or interest in the land. C. Give away the land right or interest in the land inter vivos. Or D. Enter into any other transaction in relating to the land, right or interest in the land without the written consent of the other spouse, which consent shall not be unreasonably withheld. Would you say that Section 47 only applies to land jointly acquired during the marriage?
No, it does not appear so. The key words in Section 47 of Act 1036 are the valuable land acquired for valuable consideration during the marriage. In simple terms, valuable consideration means exchanging something of value for something else. In most instances, it's money. And so going by the key words, it means that any land, whether jointly purchased by the spouses or purchased by one spouse, the restrictions in Section 47 of Act 1036 would apply. And so it's not limited to land jointly acquired by the parties. This means that even if your spouse did not contribute financially towards the acquisition of the land, you will still need their written consent to deal with the land in any way. However, going by the keywords again, it excludes gifts and an inheritance or lands purchased prior to the marriage.
Okay, so it just seems to protect the land that were acquired during the marriage. So marriage, the Act doesn't say, does it apply to all types of marriages?
Yes, Act 1036 does not define marriage. And so my view is that marriage in this instance refers to the 3 types of marriage recognized under Ghanaian law, which is customary marriage, Mohammedan marriage, and then Christian and other types of marriages, which we formally used to refer as the ordinance marriage.
Interesting. So, Gloria, if my marriage is not monogamous, for example, I have 2 or more wives, and I want to dispose of land that I acquired during the marriage for valuable consideration, whose consent do I seek? Is it one wife or all the wives?
It will depend. Again, going back to the key words, land acquired for valuable consideration during the marriage. And so if the land that the husband wants to dispose of was acquired during the course of the marriage with all the spouses, then he would need each spouse's written consent. But if, for instance, the land was purchased prior to the third wife, prior to the spouse marrying the third wife, then you would not require the third wife's consent, because going by the key words, it's land acquired during the marriage. And at the time, the husband was not married to the third wife.
Oh, wow. So that means that with more spouses, more responsibility. You have to be looking for written consent for each of your spouses.
Yes, it appears so. Again, that going by the key words, it says that land acquired during the marriage. And so, what is your take or view on land acquired before the marriage by one spouse, but then the other spouse built on that land? Do you think that the restrictions in Section 47 would apply?
Well, if we are going to go by a strict interpretation of Section 47, then that land, so far as it was acquired before the marriage, would be excluded from the restrictions under Section 47. Yes, I know the Lands Act would define land to include the property or the buildings on it, even crop. But the key words that we've been using today, it is acquired during the marriage. So if you acquired before the marriage, even if your spouse enhances the land, adds to the value, develops it, that will still, I believe, will be excluded under 47 because it was purchased before the marriage. And so Section 47 would not apply to that land. But however, it's be interesting to see how a court will look at it, whether the courts will be inclined to try and protect the interest of the spouse who has developed or built on such a land.
Yeah, I believe so. I think that it would be unfair for the courts to conclude that such a spouse, the spouse who builds on the land's consent, should not be sought, because in one way or the other, that spouse has enhanced the land. But again, like you rightly said, it would be interesting to see how the court will deal with such a situation.
Okay. So, Gloria, other interesting phrases that come up: withholding consent, good reason to withhold consent, unreasonably withholding consent. What does the law consider a good reason to withhold consent?
Act 1036 does not define good reason or what constitutes unreasonable consent. The memorandum to the Act does not also shed any light on that. And so we looked at cases in other contexts. And in Ado and Ado, in that case, the court determined whether a spouse had unreasonably withheld their consent to the grant of the dissolution of their marriage. And this was the court's view. Whether or not consent is being unreasonably withheld is a question of fact in each case. The test is objective, and would a reasonable spouse placed in such a situation withhold their consent, all the facts must be looked at. And so I want to believe that within the context of Section 47, in instances where the court have to determine whether or not a good reason has been given, or whether or not a spouse is unreasonably withholding their consent, the court would look at the peculiar facts of the matter. It would look at the peculiar facts of the matter, and so there wouldn't be one reason that we would all say that must be the reason. We wouldn't have one good reason. What constitutes good reason would depend on the peculiar facts of the case. What do you think that?
I would agree with you that it will not be a one-size-fits-all kind of scenario. And so what would constitute unreasonably withholding consent will depend on the circumstances of each case. And we came across a case. Now, this is a district court case. We don't know whether we haven't come across it being overturned on appeal. But this is the case that we are considering today. This is Muhammad Yusuf against Aishetu Musa. It was determined in February 2023, so it's fairly recent. Now, in this case, it was the purchaser who took the matter to court. The purchaser sued the defendant, who was the wife of Mr. Baba, Mr. Baba, who sold the property to the purchaser. Now, Mr. Baba sold the property to the purchaser, and they had an agreed date that he was supposed to hand vacant possession of the property to the purchaser. But his wife, the defendant, refused to vacate the premises. And she initially went to the palace for some resolution. The palace determined that she was unhappy with the new property they were moving into. And so the plaintiff was asked to, at his own expense, do the repairs that she sought. And then she still refused to vacate. And so the plaintiff took the matter to court. The court looked at the circumstances, the reason behind the sale. And what the court's view was that the defendant knew about the sale. She knew that her husband, Mr. Baba, needed to sell the property to pay for school fees for a child, to pay medical expenses for another, and even to develop the new property they were moving into. And so, in the court's view, looking at all these things, she was unreasonably withholding her consent. And so the court validated the sale of the property to the plaintiff and then ordered the defendant to hand over vacant possession to him. Now, I'll say that looking at this, probably what we should say that as a couple or a spouse in a marriage, ultimately, you need some sort of written consent or agreement from your spouse to dispose of land, so long as you acquired it during the course of the marriage and for valuable consideration. And so, by law, you should have a written agreement if you are purchasing land. That specifically exempts the restrictions under 47 in the sale exchange, yes, of that land. You should do it when you are acquiring the land, which I'm sure everybody is happy about, and so people will be more inclined to consent. Or if you don't get that, then you need the written consent of your spouse to deal with the land.
It will be difficult after the purchase, especially if you do not disclose it at the onset.
Exactly. And so that just says that you have to be transparent. You need to let your spouse know what you are doing with money, even if there's no financial contribution from their end. And of course, the third one is that you should have a good reason for disposing of your property.
But you see, Dad, where I have purchased the property with my own funds, shouldn't I be at liberty to dispose the land in any way that I want to, or deal with the land in any way? Why do I need my spouse's consent? Well, especially when my spouse did not contribute towards the acquisition.
Well, I know we are trying to move away from what kind of contribution. This is probably what the law is trying to do. But contribution can be more than financial. And the law is also trying to give an advantage to the spouse that may probably not have the wherewithal or the power. So they are probably giving an advantage to the one with the lesser power in the marriage. And of course, it also says that be transparent. Don't go hiding your assets. And then after you, God forbid, die, we are now looking for your properties. I agree with you, it's not fair, but it is looking to resolve something. Whether it does that, it's another issue. Well, Gloria, let's go back to the issue of consent, withholding the consent. It appears that then if in your view, your spouse is unreasonably withholding consent, your remedy is the courts. But is this realistic to expect a spouse to sue their spouse just because they want to deal with their interest in land?
Well, it depends. If the parties are already on the verge of divorcing, then one may be more than happy to go to the court to sue the other spouse. But where the parties are happily married, it would be difficult for one to sue the other spouse simply because they want to deal with the land in any way. In the case that we looked at, Yusuf and Musa case, you would note that it was actually the purchaser who sued the spouse that was being unreasonable. And interestingly, Mr. Baba, the spouse's husband, testified in the matter. So who knows? Perhaps he might have even encouraged the purchaser that, well, I can sue my spouse, and so please sue my spouse, and I would definitely come to court and testify on your behalf. So it would really depend on whether the parties are happily married or they are on the verge of divorcing.
Please, but if you're happily married, don't be Mr. Baba. Don't be testifying on behalf of the purchaser. Anyway.
We believe that this has been an interesting discussion and many of you would have a lot of questions. We'll definitely come back with a part 2 of this interesting topic. In the interim, please do continue this conversation in your homes and in your offices. And please do let us know whether you believe Section 47 of Act 1036 achieves its purpose, or whether this is a potential catalyst for confusion between spouses. Thank you.